Hey, let's get started here. Welcome. My name is Mark Harmon, and I'm going to be the moderator for this event. Let me just introduce myself before we go much further. I am the contracts director for a firm named LPA Inc. LPA is a Irvine-based firm with 6 offices in California and Texas. We have over 400 employees. We've been around for over 50 years. And one of the things that distinguishes is LPA from other firms, perhaps, is that we're a fully integrated firm. So we not only have architects in-house, but we have mechanical and civil and landscape and structural engineering in-house. So again, that's my name. I'm Mark Harmon. I'm with LPA Inc. I will let the other presenters present themselves when they do their slides. Prior to being at LPA, I was with AECOM for 15 years, playing a similar role. And then prior to that, I was with the Ralph M. Parsons Company. So again, thanks for carving out some time for us tonight. And we're happy to have you. As is the case with probably many of your firms, LPA is very proud of the project, the places and spaces that it designs. And we frequently here at LPA will have presentations that showcase a project. These are beautiful projects, you know, they're aesthetically pleasing. They add great value to their communities. And again, LPA is very proud of them. However, during these presentations, I can't help but wonder often and dwell upon the issues and disputes that I know about those projects. I just can't help it. I just can't resist that temptation. And invariably, I think about the contracts language in those contracts. And you know, I just again can't help it because that's what I do. I sit and review contracts all day and I talk about them. So I'm just naturally wired that way. So these are the things that keep people like our panelists up at night. They think about these contracts all the time. So today we want to share our perspectives on the good, the bad, and the ugly in these contracts. And we're hoping it'll help provide you some insight into what we're looking for. Now, I no doubt your firms already provide guidance on these terms, that these issues that we're going to talk about today. We're certainly not here to supplant or contradict that that guidance your firms provide, but we're here to kind of we believe to kind of support that and to elaborate on that. And we think what you're going to hear today is going to be in concert with what you're hearing from your firms already. So we're hoping that'll help you. And also, I wanted to add that we're not here to provide legal advice. This doesn't purport to be, legal advice. This is, again, just some perspectives from people in the industry that sit and review and look at contracts all day. So if we can go to the next slide. This is our panelists. Again, we'll all introduce ourselves. We have 3 panelists, and then we have me, the moderator. If we go to the next slide. And here's our agenda. As you can see, it's a pretty brief agenda, but we have a lot of information that we're going to share with you. One of the things that I wanted to let you know that we're also, in addition to what you see here, we're also going to provide you with some case studies, a couple case studies that I think you're going to find very interesting. And those are going to underscore some of the points that we're talking about in this presentation. And then the third to last bullet, if you will, is something called maximizing the contract review value. This is something that I haven't seen at many presentations, but I think it's worth addressing. This is basically some tips and some guidance on how best to engage the person that reviews contracts for you at your firm. I think we have some helpful tips we'd like to share with you to kind of facilitate that process. And then finally, we have we're going to have a Q&A. We love questions, but go ahead and post your questions during the presentations. There's a chat room feature or a chat feature where you can do that. But what we'd like to do is hold off on answering those questions to the end. And the reason we're doing that is we want to make sure we get through these presentations. So if you can go ahead and submit your questions in the chat room, we'll answer those at the very end. So we'd appreciate that if you could have some patience with us on that. And we have some polls. We're going to be doing a few polls throughout this presentation. And Karina, if you could show the first poll, I thought we'd do the first one right here and now. There we go. What percentage of time does your firm contract with clients using AIA contracts?
Okay, let's begin with the project specific terms.
Oh, hold on, Merdad. We want to share the poll.
Do I have control of the slides?
No, you just tell when you're ready to advance the slide, you just say advance the slide. Oh, here we go. I say less than 5%. That's what I said. So, but you know, from our sides, we actually use AI quite a bit. So less than 5% is not a few. Merdad, yes, advance the slide, Lauren.
Okay, there's some audio problem. I'm having some difficulty hearing you properly, but let's begin, and I'm going to depend on Lauren or somebody to change the slides for me at the right time. Well, every contract that an architect or another design professional signs with a client has basically two sets of terms. First are terms that are unique to that agreement, which we call project-specific terms. And then, of course, there are the more general terms. My portion of this presentation is to focus on the project-specific terms. Now, the first project-specific term that's unique to every contract is the parties to the agreement. And those parties, on one side, we have a design professional or an architect specifically. On the other side, we have a client. The client may be an entity, it may be a governmental institution, it may be an individual. An important thing for architects and some other design professionals to be aware of is that if the client is the owner of the site, then under California law, they have design professional lien rights on that particular property. Otherwise, they don't. Next slide, please. The next specific item is the project itself. Again, that's a unique aspect of each contract. And with the project, there's three things to consider. The first one is the identification of the project. And identification of the project is different from the project scope. Then, of course, we have the project scope and the project parameters. If you use the AIA B101 agreement, there's this Article 1.1, which is sort of the initial assumptions, kind of sets the stage for the contract. Those are the kinds of areas that are affected by project parameters. So project parameters deal with things like project size, the budget for the project, critical timelines, critical approval or permits on which the project may be contingent or may depend. And then under scope, we have the services that the architect or design professional is supposed to provide under the agreement, the sub-consultants that are included, then the sequence and phasing of the services that are offered. Next slide, please. One of the key issues about scope is to not give it short shrift. Frequently, architects, when they work on a project, they've been dealing with it. When they write the contract, they've been dealing with the project for some time, and they tend to keep a lot of things in their head and not put down on paper what exactly the scope includes and excludes, and what are the specific qualifications to scope. It's really important to lay those out because those are the Those are the aspects of the project scope that can lead to what we call scope creep and can cause problems down the road. Next slide, please. Scope under the AIA system or AIA contract documents, there's three categories of scopes that's included as basic services, scope that's will be covered as additional services or supplemental services. The only difference between supplemental services and additional services is that supplemental services are known at the start of the project. The parties know about them. They may even have an agreed price. It's just a menu item that they have not yet decided whether to include or not, but they've agreed on the price. Additional services, on the other hand, are typically unknown. You may have some general categories of additional services that may arise, but actual additional services are not authorized at the time of contracting. They'll be authorized at a later time. Basic services are what the basic fee is tied to. Next slide, please. So there's this symbiotic relationship between parameters and scope. Parameters can impact the scope. So for instance, if the size of the project increases after the contract is entered into, that affects scope. If the size of the project is reduced, it may affect the scope. If the schedule is accelerated, it may affect the scope. So those parameters are factors that have a direct impact upon the scope. And this is the reason why it's important to lay out in the contract the basic parameters on which the fee and the architect or the designer's proposal is based. Next slide, please. Every project has what we call a burn rate. Burn rate is the cost of production of that project. It's the cost of labor, essentially, this professional time and staff time that goes into producing the services, providing the services for that project. Now, if the burn rate for the project exceeds the project fee, not always, but sometimes the reason for that is scope creep. And scope creep sometimes occurs when there is a change in project parameters after the agreement is entered into. And those project parameters, as they change, they have a direct impact on the scope, and they cause the architect or the designer to experience that higher burn rate. We had a project case a number of years ago where it was a food processing plant, and in the middle of the contract, the head of the company passed away and his sons took over, and they started to travel around the world and experiment with different manufacturing equipment with different specifications. And they kept sending that information to the architect from Germany and Japan and other places where they were looking at equipment. And all of a sudden, the architect experienced incredible scope creep, that they discovered that in the course of trying out these different equipment and manufacturing equipment, they had actually, dealing with the electrical and mechanical requirements of the equipment, they had burned a lot of their fees without making the progress that they assumed they would make, commensurate with that fee. Next slide, please. So scope creep can happen for a variety of reasons, but one of them is project parameters. So what happens when you experience a change in project parameters? The architect has to immediately, or as soon as possible, demand, request an authorization for additional services, or change in services as they're sometimes called. Of course, this, if the agreement is hourly, which is not the case usually, this is not an issue. You just provide the services on an hourly basis. But if it's a lump sum fee, it's very important that as soon as you become aware that the changing project parameters have an impact on the scope, that this is brought up and raised immediately with the client and a request is submitted to the client to authorize additional services that are caused by those changing project parameters. Next slide, please. The next specific item, the next project-specific term is, of course, the fee. And the fees can be structured on a variety of different bases. It could be a lump sum fee, an hourly fee, percentage of construction cost, cost per square foot, or a hybrid of these four. The lump sum fee is generally based on a projection of hours. And this is why it's very important to lay out the project scope and the project parameters very clearly, because those projections could be upset by any change in the project scope and any change in project parameters that would impact the project scope. If the fee is hourly, obviously it's the most flexible approach. You provide the services on an hourly basis, and it doesn't really matter. There's no distinction between basic services and additional services if the agreement is hourly. If it's based on a percentage of construction cost, to some extent it's self-adjusting. It goes up and down with the cost. But even then there are complications. We don't have time to go into them. But if the fee is based on a percentage of construction cost, then you must lay out very clearly a definition of the construction cost. So for example, does the construction cost cover all the systems that are included, even if they were not provided or coordinated by the architect? For example, does it include the sprinkler system, which was designed and built by somebody else? Those are the kinds of things that lead to conflicts when you have a percentage of construction cost fee method. The cost per square foot method is relatively rare. It's typically used in interior projects when large interior floor plates are being planned. You go on a cost per square foot, but it's relatively rare. Next slide, please. And of course, tied to the fee is the payment schedule. So the payment schedule it could be per phase or milestone, but typically it's monthly, even though it may be set on a per phase basis, but it's billed on a monthly basis parallel to the progress of the project. Next slide, please. Insurance is, of course, a general topic, but each client has unique insurance requirements. They typically specify what kind of insurance they require. And so it becomes nuanced and it becomes a project specific term. Clearly the coverage amounts should be proportional to the fee and reasonable in light of the scope of the project. So, for example, if an architect is required to provide coverage of several $1 million, the architect's lighting designer, who has a much smaller piece of the project and maybe under a contract with the architect, should not be required to provide that same level of insurance coverage, which is what sometimes clients ask for. They just throw in a blanket statement, the architect and all of the architect's clients must provide this much insurance. Well, this is not always possible because those subconsultants of the architect that have a smaller piece of the project may not be able to afford for that project the cost of insurance at the level that the architect is required to provide. Condominium projects have their own insurance requirements. A lot of condominium projects provide wrap insurance. You must be aware that wrap insurance doesn't cover professional liability. So it basically covers the contractors and the subs, but doesn't give much protection to the architect. So do not take a lot of comfort in a wrap policy. The length of time that's an architect or designer is required to carry their professional liability insurance is a point of contention. Because the statute of limitations are 10 years from the date of substantial completion, a lot of clients want insurance for 10 years starting upon substantial completion. Now, given the fact that the average project may take 4 or 5 years to design and construct, you're looking at a period of 10, 15 years during which you're contractually required to provide insurance, which is a very onerous requirement and not wise. So typically, I recommend no more than 3 years from substantial completion or 3 years from the termination of the architect's services. Insurance brokers obviously can guide you through the nuances of that of the various types of insurance. We don't really have the time to get into that now. Next slide, please. Dispute resolution is another of those general terms of the agreement, which is nuanced and customized depending on the requirement of the client. Some clients, for example, avoid courts and juries. Celebrity clients are typically in that category. They don't want the publicity. So they opt for arbitration. Other clients want litigation. They don't want arbitration. So you have to see what the client requires and consider the risks of the project. Typically, arbitration these days tends to be actually more expensive than litigation because arbitrators cost money and judges don't, and it's less structured. So arbitration nowadays is a little bit disfavored by insurance companies and a lot of parties, but still some clients prefer them. The important thing is if you have sub-consultants, you cannot accept terms in their proposal about dispute resolution that are different from the terms of the prime agreement, meaning the agreement between the architect and the client. So it's very important to make those proposals from subcontractors subordinate to the prime agreement between the architect and the client. Those should be all what we call flow-down provisions that the prime agreement should govern. Next slide, please. Intellectual property is another one of those general topics which again can be nuanced because of specific client requirements. There's a distinction between ownership of intellectual property, ownership of copyrights, and a license. Typically, a non-exclusive license can give a client almost all of the rights that ownership would give that client. So you should always try for a non-exclusive license rather than giving ownership of copyrights away. It should be conditioned on the payment of the fee so that the contract language should not allow the client to assume ownership of the intellectual property without having paid the fee of the architect. So again, that's a topic that's nuanced. It also impacts consultants. I've found in my experience that most clients, when it's explained to them that a license can provide them with the same rights as ownership, they generally opt for the license. They're okay with the license as long as they can have access to the drawings and they can use the drawings for future remodelings or occupancy and maintenance of the project. Next slide, please. We get to the standard terms, so I pass you on to Evan.
Thank you very much. But before we have the opportunity to hear from Evan, Corinne, let's do another poll. Oh, this is an interesting one. Which part of the contract most frequently holds up the signing of your contracts? Green, it's too bad you didn't have a drum roll. Oh, it's on these. Indemnity, just like I suspected. And no doubt Evan's gonna talk a little bit about indemnity, I suspect, in this. In any event, thank you very much for that, Merdad. And without further ado, Evan.
Hi, everybody. I'm Evan Grant. I'm a senior counsel at AECOM. I've been in-house for the last 7.5 years, always in the architecture and engineering space. So it's an industry that I really enjoy. I like working with creative people and smart people, and so this is a perfect place to do that. So I'll kick things off with the standard terms. These are the terms that you may hear referred to as boilerplate. And I think the most dangerous phrase in the professional services industry is, oh, just skim it, it's boilerplate. People get burned left and right. And I think, you know, as an attorney, the message that I always want to send to project managers and architects is that everything is negotiable. Everything remains on the table until both parties have signed on the dotted line. So skimming a provision because it's something that you see in every agreement is dangerous. You know, the devil's in the details, and the words really do matter. And you'll see some examples of that in my portion and then in Eugene's portion as well. So we'll start here on the standard terms, know your forms slide. Some of these industry forms can be a helpful source for language. They can give you some perspective on how the industry addresses common issues. So the first one you'll see is the AIA form. AIA, near and dear to most of us, I think. The AIA produces Series A through Series G. Each letter has a different purpose and a different intended audience. Here for this group, the series that you'll see most frequently is probably Section B. The B series documents govern owner to architect agreements. In addition to the AIA, you'll hear about the consensus docs. Consensus docs were developed largely by the Associated General Contractors with some input from owners and a little input here and there from the rest of the industry. They've been around for about 15 years now. Contrast that with the AIA documents, which I think have been around for at least 85 years now. It's worth noting the AIA did not participate in drafting the consensus docs. Consensus docs are generally seen as more contractor favoring, owner favoring, and as limiting the architect's role, particularly during the construction phase of work. You may also hear about the EJCDC forms. That's the Engineers Joint Contract Documents Committee. They're primarily used in the civil engineering field, but they can provide some useful language to architect agreements as well. And then last but not least, you have the Design Build Industry Association, the DBIA. They produce a number of sets of forms, but they're all geared towards design build procurements as opposed to design bid build procurements. The form that you would most often come across as an architect or a design professional is probably the DBIA 540. And that's a subcontract from a design builder to an architect or engineer. So next slide. So we'll start jumping into some of the particular standard terms. Again, these are terms that you'll see in just about every professional services agreement. And based on the poll, I think indemnity is probably top of mind for most. You know, first things first, I just like to define what an indemnification obligation is. So it's a contractual obligation to hold another party harmless for claims or damages. In its broadest form, an indemnification obligation can be triggered without fault. That's referred to as broad form indemnification. It's worth noting about 45 states have placed some limitations on contractual indemnification. In most states, they're referred to as anti-indemnity laws. Generally, they void indemnification obligations in the event of the sole fault of the indemnity. So the indemnity is the party that receives the indemnification obligations from the indemnitor. So again, 45 states have some limitations, some go further than others. California is in that group. California Civil Code 2872 limits a design professional's indemnification obligations to the extent that damages, and fair warning, this part is a quote, arise out of, pertain to, or relate to the negligence, recklessness, or willful misconduct of the design professional. So the emphasis there is really a negligence-based standard of care. And we'll talk about standard of care a little bit further down. So alongside indemnification obligations, you've probably heard the duty to defend. And the duty to defend is a separate duty from an indemnification obligation. It's a contractual obligation to defend another party against claims. So where indemnification looks at damages once they've been incurred, and then the indemnifying party pays them back, a duty to defend is immediate. It's an independent, immediate duty as soon as a claim is brought and tendered to you. If you've given contractual indemnification and you have a duty to defend, then you have an immediate duty. It's important because those costs can really stack up. Another California wrinkle there is that the duty to defend is implied in a contractual indemnification obligation. So you cannot carve your duty to defend out unless it's explicit, and you can generally fall back on California statutes, which make the design professionals' duty to defend conditioned to the extent of their fault. Again, it's an immediate duty. You will be paying those costs out up front, or ideally your insurance, but you may, under California law, be able to recover those defense costs on the back end, as well as the proportional indemnity. So a few things to look at when you have an indemnification obligation. The first thing you want to check is that it's limited to claims brought by third parties. So because it's a contractual obligation to hold another party harmless, you don't want to make that obligation direct. The scenario that I usually bring up is breach of contract. So let's say that you have an indemnification obligation and a duty to defend, and it's not limited to third-party claims. Then your counterparty could bring a breach of contract claim against you, and you would be obligated to pay for their legal costs. That's kind of the worst case scenario that you try to avoid by limiting your indemnification obligations to claims brought by third parties. Another important item to look at, particularly outside of California, you want to make sure your indemnification obligation is limited to the extent of your fault. So again, California has statutes. We have Civil Code 2872 specific to design professionals, but you do have to make sure that you're not opting out of any of the protections that you would otherwise have. And then last but not least, you just want to look at your duty to defend, understand when those costs are payable, and what, if anything, you may be able to recover on the back end to the extent that you're not found to be at fault. So we'll move to the next slide. Oh, actually, I jumped ahead. If we can go back. So standard of care and warranties. This language is largely settled. You'll see something very similar to what's in the AIA B102. The architect shall perform its services consistent with the professional skill and care ordinarily provided by the profession, essentially. Again, I alluded to it earlier, this professional skill and care ordinarily provided within the practice essentially sets up a negligence standard. So if you fail to meet that standard, you're generally deemed negligent. That's an important distinction because professional liability policies cover negligent acts, errors, and omissions. They don't cover intentional misrepresentations or fraud. They don't cover breach of contract unless it arises from negligence, and they don't cover breach of warranty or breach of guarantees. So you have to be very careful when you're reading a standard of care to make sure that the client has not elevated your standard of care in the contract documents, in the scope, because that can put you outside of the coverage of your professional liability policy. So how do you do that? You want to keep an eye out for warranties, guarantees, language like best, state of the art, etc. So keep an eye out for warranties. The most common in the architect or design professional context is the warranty of fitness for purpose or a guarantee of project performance. Again, those are generally outside of the confines of your professional liability policy. Another sort of seems like a small point, but particularly risky point for architects is compliance with all laws. It seems reasonable that we would all be complying with the law. We're all acting in good faith. But in the architecture context, there are often overlapping authorities, a structure maybe in multiple jurisdictions. You may have to comply with local codes, but also OSHA. And there may be conflicts between those varying standards. And so when you accept a standard of care that includes compliance with all laws, you may be the party that's obligated to resolve those different standards. And that may not be a simple task. So something that I always recommend internal clients look at is the B101 Section 3, which has great language regarding reviewing applicable laws rather than ensuring compliance with all laws. Along the lines of standard of care and warranties, you really can't get through a discussion without talking about the fiduciary standard. That's something that Eugene will talk about more in the case studies that we have coming up, but keep in mind that that is essentially the highest elevation of standard of care. And it goes beyond the arm's length relationship that businesses typically have with one another and that design professionals typically have with a client. So again, words matter, and you'll see a couple of examples that really turned on one or two words. Next slide. So we'll transition over to waiver of consequential damages. I think this is often a provision that people gloss over, but it can be wildly important for allocation of risk in the event of a claim. So the first thing people always ask is, well, what's a consequential damage? And the issue is that there isn't a bright line definition. It depends upon the jurisdiction, and frankly, it's often a litigated matter. The good news is that there are some quintessential examples. So actual damages generally are broken down into direct damages or consequential damages. Consequential damages generally are damages flowing from the breach, flowing from the failure to comply with a standard. The best example of a direct damage is the cost to correct defective work. The best example of a consequential damage is lost profits while doing so. So people always ask, what could go wrong? This is such a small scope of work, or what could go wrong? I'm one party among 15 other design professionals on a job. And the example that I always turn to is a case Perini v. Great Bay Hotel and Casino. So Perini, construction contractor, the analogy still holds for the design professional world, but construction contractor providing a $600,000 scope of work, relatively small value on a casino project. And by the end of the project, there were allegations that Perini had delayed the opening of this Great Bay Hotel and Casino. And ultimately, there was a $14.5 million decision in favor of the casino. And so Perini's $600,000, which with the sin margins everyone's operating on could have been $60,000 in profit or less, ends up with a $14.5 million judgment. So some further examples of CDs: lost rents, loss of tax credits, which is particularly important in the green construction world, damage to reputation, down or idle time, interest and finance charges, material escalation, rental costs, loss of productivity, etc. So what can you do about these damages? The best thing that you can do is to provide a market typical, reasonable mutual waiver of consequential damages. A great example, AIA B101, it has a very solid mutual waiver of CDs. And actually in preparing for the presentation, I was talking with Merdad and he pointed out that that Perini case is actually the reason that the AIA now includes a waiver of CDs in their standard forms. One caveat before we move on from the waiver of CDs, liquidated damages are often consequential in nature. So you may see a waiver of consequential damages that carves out those LD amounts if you have some, X number of dollars per day of delay. Next point, another really important risk shifting provision in the professional services business is the limitation of liability. So limitations of liability are intended to address those rare tail risks. Again, everybody's working on thin margins and the potential liability from a project is likely well in excess of your expected profit. And so a limit of liability is going to protect you from that rainy day. You're always expecting X dollars from this job, but there is the potential that there could be some massive cloud in the future. And so that's what the limit of liability is intended to address. It protects you against a bet the company type lawsuit. So one point that I think is often misunderstood and can be really dangerous for architects and for their firms is that the stated insurance limits in an agreement do not function as a limit of liability. I've had project managers say, oh, but the limit is $2 million. But if your firm is liable for damages in excess of that amount, to the extent that there is money to pay those damages, they're payable. And so you really have to be careful. It's something that I think makes people think twice, makes them reach out to their insurance broker, to their lawyer, to their contracts department, and just make sure that they have an LOL that's clear, that operates the way that they think it operates. So I often get asked, how can we figure an LOL that's reasonable? And so there are a couple of sort of key methods. The first is as a fraction of your fee. That's very, very common. You could also tie it to a fraction of your insurance coverage. If you're tying it to a fraction of your limits, again, just keep in mind, in a bad year, you may have multiple claims that are eroding your coverage. So you don't want to promise 100% of your policy on every single job in the event that you have two significant incidents. Again, you have to keep in mind that limits of liability can be voided by a court if they're not clear, if they're not reasonable, and if they're not mutually negotiated. Those tend to be the three tests. Again, it depends on the jurisdiction. Some states are very, very pro limits of liability, and they'll really enforce them between sophisticated parties. Other states, courts tend to step in if they feel like there may be something unfair going on. The last point on limits of liability, they are generally unavailable with a public client. So that's something to keep in mind. If you keep asking a city or a county, you may hear from their contracts department that there's a public procurement code or something else that prevents them from giving that term to you. Next slide. So the last item, and this one I'll move through relatively quickly, termination and suspension. So this is always a hot button issue, especially if you are working for a contractor. But I always find that it's easier to negotiate termination and suspension rights before you need them. It's virtually impossible to figure them out on the back end. So termination typically comes in two flavors, for cause or for convenience. Sometimes termination for cause is also referred to as termination for default. That means that the party that's terminating the agreement is doing so because the other party has materially breached the agreement. Generally, the terms in the event of termination for breach are going to be less favorable to the breaching party. You're less likely to be entitled to termination expenses. You're less likely to be entitled to payment for work in progress, things like that. I generally recommend that architects try to maintain a right to terminate for cause, and that they try to maintain a right to suspend in the event of non-payment. Anytime you have a termination for cause, you're generally entitled to notice. Just make sure that the cure period is reasonable. There are some cases where you may receive notice and have only a few days to cure or to initiate cure of the default before you can be terminated and potentially lose your fees, your profit, et cetera. And again, it's a hot button issue. It's a place where you really have to balance the legal and the business interests. So that is everything from me. I don't know if we have another poll question or if I can hand it over to Eugene.
Evan, that was a great job. I particularly like the Perini story. But before we pass the baton to Eugene, I think we should do another poll. Oh, it's an interesting question. How long on average does it take for your counsel or whoever else reviews your contracts to turn around a contract review?
Hopefully no one's on from AECOM to say 3 weeks.
Okay, waiting for those answers to flow in. All right. 4 to 7 days. We'll speak to that a little bit when we talk about the contract review, maximizing the contract review, but 4 to 7 days. Okay, without further ado, Eugene?
Yeah, thanks all for joining us tonight. I'm Eugene Tucker. I am Associate General Counsel at HOK. I've been there for 5 years. Prior to being at HOK, I worked as a construction law litigator at a firm in St. Louis, Missouri, and that's where I currently am too. And what I thought I could do today to help crystallize and kind of spell out a little bit what Mirdad and Evan were talking about, we're giving you some case studies of things that that have happened in the construction world that we've seen from other design professionals, and really show you the real life application of these concepts and theories that we spent some time talking about this evening. So the first case study I wanted to look at is the standard of care fiduciary duty. Evan did a great job of spelling out to you that, you know, what the standard of care is under the AIA document. And I agree with him. I think, you know, from my perspective, we don't really get into arguments much with standard of care. We every once and again now we'll see somebody will put, you know, we expect the highest or the best or you know, world class in a contract. But usually when you have a chance to sit with the other side and talk about that, they get it. And they, and you know, and it kind of reverts back to that language that you see in the B101. One thing I have seen though, and I want to point out and talk a little bit about, is that fiduciary duty that Evan mentioned and why it's so dangerous. To take a minute, a fiduciary duty is probably the highest type of standard of care. The fiduciary duty is something that if you accept a fiduciary duty or you are a fiduciary to someone, it means that no matter what, you will put their interests in front of your own. So what type of professions do we see create a fiduciary duty? Well, lawyers, for one. A lawyer is always supposed to put his client's interest, his or her client's interest, excuse me, in front of him or herself. A doctor would be another fiduciary relationship. You know, a doctor isn't supposed to prescribe you medicine or a specific drug if they have a financial interest. You know, it's supposed to be for what your, you know, what you require. But then the other, and really where we see it, is your bankers, your investors, those folks who are supposed to put your interest, your financial interest in front of their own. That fiduciary duty doesn't really translate to our profession, the design professions. And a perfect example of that happened with a case involving the city of Victorville out in California. And in that situation, the city retained I won't name the architectural firm, although you can probably look it up, but retained an engineering firm to provide a feasibility study, architectural engineering firm to provide a feasibility study. Costs were over budget, so the city abandoned the project. It was to look at basically electrical power plants and things of that. And the costs were so high that they abandoned the project, but they didn't pay that final invoice. So the firm in question filed a suit for that outstanding invoice, and the city filed a countersuit for breach of fiduciary duty. And what they looked at was that under the contract, some of the language included in there was this phrase that the architect engineer would act with trust and confidence for the city, would be in a relationship of trust and confidence. Now, the countersuit, so here you have an architect suing for $100,000 final invoice. The countersuit was for $52 million. So a little bit of a difference there. And the court found that no, the city was right, that this was a city that, built playgrounds and parks, and they didn't have the interest the experience or the knowledge that this architect engineering firm did. And that specifically that phrase, relationship of trust and confidence, provided a fiduciary duty. It created a fiduciary duty. And so it was a heightened standard of care, and the architect was liable to the city under that heightened standard of care. So even if their actions were reasonable, it didn't matter, that they were the fiduciary and they were supposed to look out and take that heightened standard of care. So the city wins the lawsuit, wins $52 million on the lawsuit. Now, one lesson from this is, maybe for when you have a final invoice of 100,000, you let sleeping dogs lie and you don't go after it, depending on, but again, that's something you discuss with your legal advice, your legal counsel. But the real lesson I want to talk about is that language, trust and confidence, create a relationship of trust and confidence. You will see that language. Evan referenced earlier the DBI 540. That is standard language in the DBI 540, where the designer is to have a relationship of trust and confidence with the design builder. Our practice and my practice is, when I see that, is either to cross it out or to put specific language in there saying, but all the parties agree this does not create a fiduciary relationship. And that would be something that you want to make sure you're keeping an eye out in your contracts, that you're not agreeing to language that creates that fiduciary standard, creates that relationship of trust and confidence, because courts have found that could be a fiduciary duty. All right, next case study, please, Lauren. So this one is a limitation of liability. And I like talking about these because I find a lot of times that project folks don't want to discuss limitations of liability because it can be a difficult conversation. And at the beginning of projects, everybody is in a happy mood with each other, and we're going to do a great project, and we're going to get paid on time, and there's going to be no cost overruns, and this is going to be perfect. And so let's not muck it up by talking about liability, and if there is an error, how much we have to pay or don't have to pay. It kind of puts people in a sour mood. And clients and owners do take a hard line on this. And Evan mentioned, especially state and counties, they're going to tell you we don't give limitations of liability. And even private sector clients are going to tell you, well, that doesn't make sense to me. Why should I give you a limitation of liability? If you make an error and it costs me money, it's only right that you pay for that. They'll say, I'm in business. This is one I hear. I'm in business. If I screw up, I have to pay my client to keep my client happy. Why shouldn't you? And when I hear that, it always tells me that this is someone that's not that they don't get it, because I think they do, but it's a different set of circumstances that we're operating under. As design professionals, we are not creating the same project. It's not a production line where we're putting out, Ford cars and just one after one down the line, that they're getting a unique first-time design. And more specifically, when we get into this limitation of liability, we always talk about risk, and it really is what we're trying to do is equitably share the risk. The construction industry is a risk industry. Every party needs to equally share that risk and reward. And we tell owners that, we're putting together this wonderful project for you, this wonderful building that you are going to make money from for years. But we have only one fee, and what you're paying us in fee and what we're receiving in profit really is really small compared to contract and what you're going to make. And so it's only fair, because our reward is lower, that our risk be lower as well. And so this case study that I want to talk to you about kind of takes a look at that. And so here's the situation. During a negotiation for a mixed use facility, an architect asks for a limitation of liability, and the developer states, "Oh, I've never given a limitation of liability, and I never will." Well, what do you know? Issues. And so the architect accepts it. Again, we're all in a good mood at the beginning. Why would somebody tell me maybe a half truth or not be completely honest with me? So the architect accepts that, signs the agreement with no limitation of liability. Well, lo and behold, issues arise on the project, and the architect learns that not only does the contractor have a limitation of liability, but so does the construction manager. And so what happens? The developer realizes my liability is limited. The liability is limited for the contractor and the CM. I am going to focus solely on the architect in this claim. And so I tell this story, this case study, to let you know a couple of things. One, when you hear, "I don't give limitations of liability, I never will," that's not always the truth. And this is something to continue to negotiate. Limitations of liability, you can hear it from me, are becoming industry standard. That everyone is asking for them, and people are receiving them at a high place, a greater than 50%, I will tell you, in contracts, are receiving limitations of liability. And so don't be afraid to ask, push for those limitations of liability, because this is the standard, and it is an equitable way for you to control your risk and mitigate your risk on a project. So I think that's my last case study. I think, Mark, I'm going to turn it back to you, unless we have another poll question. I think we have one more poll question.
We will have another poll question, but I did want to say that this fiduciary duty, this trust and confidence language, I think also appears in the consensus docs, if I'm not mistaken.
Oh, okay.
Yeah, don't quote me on that, but I believe that's the case.
Well,
So,
another reason to keep your eyes peeled
Yeah.
when you're going through looking for that, because they do try to stick it in places.
Good news is we don't see the consensus docs a lot. But anyways, thanks. That was a really good job, Eugene. I think we all enjoyed it. Very helpful. Next poll question, Corinne. What percentage of your firm's private clients' contracts include a limitation of liability? Well, please try to answer with candor. Well, I don't think that's we got the results here. I don't think that's inconsistent with necessarily with Eugene's observation there. But
Yeah, I think it shows that, again. Well, the 40% no idea, I understand that, but 50% are between that 25 and 100%, I guess, or at least 25 and more than 50. So that's, I do think, yeah, we're
yeah,
keep asking for it. I think that's what it tells us.
Nice takeaway. Thanks. All right, Corinne, next slide, or Lauren, thank you. So this is kind of just kind of a more of a kind of a relationship, if you oriented kind of slide, or the next couple slides will be that way. We're not going to talk about any contract terms per se here. We're just going to talk about the relationship between the person requesting the review and the person providing the review. And Eugene, Evan, and Merdad, feel free to pipe in if you like. I have no territorial interest necessarily in these slides, but I'll go ahead and speak to them, but certainly weigh in if you like. First point I wanted to make is give your reviewer time. I think I think it's fair to say that the panel would agree to this, that there's nothing worse than getting a contract review at the 11th hour. Well, there are a few things worse, let's put it that way. You know, I think foresight and planning is key to this. You know, I think the problem with getting that last second review is, well, sometimes you may not be able to get to it. And frankly, is not conducive to getting the best review possible. So you got to give the contract reviewer, your counsel, enough time to review that contract. You know, these things, sometimes it can be very lengthy. You know, when you take it into account the so-called legal terms and all the project-specific terms, you can easily have a contract that's 100 pages. So they need time. These things need to be reviewed. They need to be thought over, and then the contract feedback. Sometimes, you know, it takes time to provide that feedback and to be thoughtful about it. So please be patient. Give the contract reviewer enough time, and also keep in mind that in any given time, Merdad or Evan or Eugene may have 3 or 4 other contract reviews that they need to look at. And in addition to that, they have negotiations to do and all the other things that they need to do in their day-to-day job. So it's important to give them time. Now, once you've won the job, please sensitize your client if you can. These reviews take time. The client often will give you a client drafted agreement. Please don't provide some sort of unreasonable expectation that that review can be turned around in a day or even a couple of days. These things again need time. So please, I think it behoove you to give your contract reviewer time. The second item is when emailing the contract for review, provide some context. You know, context is very helpful and it will inform the review. What's the scope? And I'm sure, Eugene, you've probably been provided a contract and somebody said, can you review this without any context? And it's probably a little frustrating, and you probably frankly are a little loath to start reviewing it without some sort of context. Is that, again, the context will inform your review. Your context will inform your review. It's nice to know if you have any previous contracts with the client. It's good to advise the reviewer that. Often they will know. Firms have a database and they can find out, but it's good to know. It's nice to know if there have been any failed negotiation before, what happened in those previous negotiations. Those, you're not necessarily going to be wed to the past or have to, but it's good to know all that background. And how bad does the client need us? Sometimes it's not so obvious, for the contract reviewer. So if you can provide that context, I think that kind of gives the reviewer some insight on how hard they can push in the review. Next slide. Do your own independent review. I think it's important for the project managers to own their contracts, so to speak. They should go over those, particularly those scopes of services, those compensation sections, those schedule sections, and invest the time to make sure that they're pointing out things in addition to their counsel. The counsel doesn't know everything. They're very smart, obviously, but they don't know everything. And it's very helpful to have the project manager, the project team go through that scope of services and point out things that they're not going to do, things that they're not included, that they should be included. Those are things that are very important. And again, that review, I would say, don't hold up the review from your counsel. You could do it concurrently. That's probably better, because I think if you hold up the contract review because you're doing your independent review, you can you'll end up probably giving your counsel limited time to do their review. So it should be a concurrent thing, in my view. If you're a consultant to another designer or a designer to a design builder, provide the upstream agreement, if you will, the prime agreement, the design build agreement to your counsel. They're going to ask for it. You can slow down the process if they don't have it. So I think it's good to get that right off the bat, provide it to your counsel so they can look at it. And be prepared after the counsel provides their review to walk through that review with the counsel. I think that's very important because that review that you first provided could change after that discussion, could very much change. So it's important to do that, to walk through, again, it's part of a process, but it's important to do. And finally, I would say support the reviewer's position during the negotiations. We talked about the LOL and how it's not a pleasant topic to broach with your clients. But I think if everybody's showing a united front, if you will, in their own way, I think it's going to increase the opportunity to get the best contract you can get for your firm. So I don't think there's any other slides on maximizing the value of the contract review, but Eugene or Evan or Merdad, if you have anything to say about that, we'd certainly be interested in hearing what you have to say.
Yeah, I would echo your point on upstream agreements. They're so important to have. You'll see a lot of subcontracts that say that the terms flow down to the extent they're applicable to the designer's scope, and you really need to have the upstream agreement to know what you're facing. Things like changes, delays, etc., are gonna come from the upstream agreement.
I don't know about.
And it's also, oh, sorry, Mark.
Go ahead. Oh, go ahead, Eugene.
No, I was just going to say, and I think, a lot of times what Merdad and Evan talked about with those project specific and then specific terms, to remember as you're negotiating those, you're going to have those same negotiations with your subconsultant too. And that's another good leverage point for, when you're dealing with your client or your owner, is to say, well, listen, yeah, you can try and say, I don't get a limitation of liability, but my subs are going to want one too. And this makes it difficult for them, or this, you don't want to take out trust and confidence. Well, the subs aren't going to sign up for that either. They have lawyers who look at it as well. So we're getting into a fight that does have consequences downstream. So, you're up front, or you're fighting hard to get those into the prime agreement, because you're going to have to fight a lot of those same things on downstream as well.
You make a really good point. I think it's important to convey to the owner that these impacts, these terms have impacts on the consultants, and they could scare away otherwise good consultants to help them in the project. And especially and it could really have a disparate impact on disadvantaged businesses, small businesses, women-owned businesses. I think that's an important point to make. Also, I would say if you had the chance, I'm sure your counsel would love to have an opportunity to see the design build agreement, those design build projects before the design builder signs their agreement, knowing that the design builder is going to try to ram a lot of the stuff down the designer's throat. So I think they'd like to have the opportunity to propose some changes that the design builder can make with their client. They have the opportunity. So I think we're done with that slide, this element, if you will, of the presentation, and we're ready to go into the Q&A. So next slide, Lauren. So we didn't get a lot of questions, but we did get one from Louisa. Are you on the line?
Oh, hi. Yes, I'm still here.
Yeah, Louisa, go ahead and propose your question. I think you raised it when Evan was talking about the defense obligation. And
yeah, it was just more of a clarification. A couple times the lawyer said a certain thing was settled, and I was wondering what
that meant.
To clarify, are the AIA documents more settled than, say, other documents? And clarify. Thanks.
Yeah, as far as the standard of care, the AIA documents are used pretty broadly. They're cited. Even in private contracts, you'll see that language copied and pasted pretty frequently. So when I was saying settled, I think it's a provision that you're not likely to see a ton of changes to in the market. And I think a lot of that is driven by insurance coverage. The thing that you do have to be careful about is parties will put that language in and define it as the standard of care, but then in 10 or 12 other places, they'll have state of the art, best, language that sort of quietly elevates the standard in the background.
What I see a lot lately, Evan, is people like to add clients, a lot of clients, I see it in text, they can't resist the temptation to say they want your design to be free from material defects. So, I find it very annoying.
Yeah, I always push back on that provision by
Yeah.
pointing out that, a
So-
design is not free from defects in the same way that a product is. And so
Mhm.
that language is really more construction focused rather than it is applicable to, a designer's services.
Yeah.
It doesn't always work, but it's a reasonable explanation, I think.
Well, thank you for that. Jessica, you have a question?
I'm wondering if the panel could speak briefly about attorney-client privilege and some of the pitfalls that may occur during negotiations on particularly contentious terms, and about, best practices for maybe not forwarding direct messages from in-house counsel to the other party, things of that nature.
Yeah, I can talk to that. I think that's a great point, and that's something that we we see more often than we'd like to. I think is that you send comments to someone and it just gets forwarded on, and a lot of those were meant to be internal comments. So just to take a step, the attorney-client privilege is really only invoked when you are going to a lawyer seeking advice, seeking legal advice, or seeking counsel. The story I always tell is from when I was in private practice of what not to do. I represented an owner on a project, and he was in litigation with the contractor, and the contractor sent him an email and said, "I don't know why you're disputing this. We had a meeting and you told me to do X." And the owner took that email and he forwarded it to his number two. And he said, "Can you believe this guy? He actually thinks I said that." And the number two responded saying, "He's 100% right. I was in that meeting. You definitely said that." And then he forwarded those emails to me and say, "I'm adding Eugene to invoke the attorney-client privilege so that none of this is it." That doesn't work because you can't just add an attorney and think that, we get this cloak and no one will ever hear what you say. So you need to be asking for legal advice or seeking counsel or guidance. The flip side of that coin is that as attorneys, we live by a code of ethics, just as architects have their ethics. And one of the main ethical points of ours is that if you believe something as an attorney has been sent to you by mistake, or that wasn't meant to be sent to you, you do have an ethical obligation to return it to that attorney, and without reading it, or at least reading it up until the point that you recognize that there were privileged communications or someone was seeking advice, to turn over and say, "I think this was sent to me by accident." Again, that used to happen to me a lot when I was in private practice. I had a case where the associate on the other side, his name was also Eugene. And so any day that something was due, a brief or a draft, it would get sent to me and we just, "What do you think about this argument?" And you have to send "I'm destroying this, but please, I think you sent it to me incorrectly." So when it comes to that, hopefully if another attorney is on the other side, they will have those same kind of ethical, be led by that same kind of ethical guidance and not use that information and would destroy it. But it is something I think you, Jessica, you bring up a good point, and it's something that project teams need to be careful about, is not just forwarding on, going through, and Mark hit the nail on the head of this, of, having that foresight to review those comments and review them with the attorney to say, "I see there's some internal comments here. What can we share? What can we not share? How do we, how can we communicate that?" And then again, you're both on the same page. And I think that's going to help even more. So.
Very nice. I actually fielded a few questions from some architects offline here. I'll raise them to the panel. The first one is this is from the questioner here. "If I am in a difficult contract negotiation, what are the 3 most important deal points that I must win, and why?" Obviously, you don't have a project-specific context, but they're looking for kind of a general question.
I mean, for me, it's a limit of liability, a waiver of consequential damages, and an understanding of the indemnification. But I think from a business perspective, there's more nuance to the exclusions and qualifications. But if I had to pick 3 legal items, those would probably be my 3.
I think
Go ahead,
it's
Bernard.
very important to understand, as I'm sure anyone who's negotiated contracts knows, contracts are also very much driven by the market conditions as to which side has the upper hand. And if market conditions are bad, people take risks, do anything to get that project. If market conditions are good, they're in demand, they don't need the work, you can afford to negotiate. So that's always a crucial factor. What is the environment of that negotiation? That's generally, that determines a lot of other things and how far you can go.
Yeah, thanks for keeping it real, Merdad. You're right. I mean, that's the case. All right. here's
I would
another
just
one.
Mark, if I could just add one more thing. I think both those are excellent points, and I agree with Evan. Those are probably the top 3. But just to remember that there is also the death by 1,000 cuts too. That there are sometimes, and I always say too, you get a good limitation of liability that can alleviate a lot of other concerns I have with contractual language if it's a good strong one. But you can deal with death by 1,000 cuts of to Evan's point, sometimes we get people want to say your basic services include all necessary. Those vague terms that are going to be put in your face when you start asking for ad services and things like that. So while there are definitely, I think those are the big 3 that we look for too. You just remember that there's other ways that you can other things to be aware of too.
And all services necessary can put you in the red, right?
Yeah.
So,
And permitting risk as well.
yeah.
That's one that always jumps out to me that qualifications don't necessarily include.
Very good. Very good. Very nice. Thanks, guys. Here's another one. It says, if I am operating a small practice and need to be judicious with my fee, is there a cost-effective approach to gain help in understanding and negotiating contracts? I think, well, I think hire good counsel to help guide you. I mean, I'm trying to understand what the question beneath the question is. You know what I mean? So if I'm operating a small practice and need to be judicious with my fee, is there a cost-effective approach to gain help in understanding and negotiating contracts? Well, sometimes reaching out to their insurance broker can be helpful. I think
by going to programs like this, you could get a very good understanding of contracts by attending these types of seminars and becoming aware. And then reading the contracts carefully and negotiating, understanding the other side's position, understanding the project, giving yourself enough time to cover all the details. Those are a lot of that, it's on the shoulders of the principals, not so much the legal advisors or the attorneys.
And
They really have to shepherd that contract through.
Jessica, I see your note here. You're right. AI has a great resource for people that want to learn about contracts. Putting a plug here for our AA, and they well deserved plug. Jessica, you said the AI Trust also has a legal line with a database by state for petitioners who may be looking for legal services. And I believe they may have a subscription service still for general legal principles. So AIA offers a lot of tools to help people.
You also get practitioners who really know the area, which I think is important. Not all lawyers are the same. Not all lawyers know an architecture agreement from, an agreement to sell a yacht. So if you find someone who specializes, maybe the price will seem a little higher by the hour, but you'll pay for fewer hours. And, so there's some balancing there.
Kind of reminds me of my brother. My oldest brother's a surgeon. And sometimes when we're at social gatherings, people start asking him all sorts of questions that have nothing to do with surgery that he couldn't possibly answer because he doesn't have that expertise. I always find it kind of funny, but he's very patient and he tries to, kind of fend them off. Anyways, here's another one. Do you feel that the AIA documents favor the architect, owner, and contractor equally, or do they lean in one direction or the other? Is there one feature that you would like to see edited to create a better balance? That's an interesting question to raise in this this forum. I think there's a perception, certainly in the among owners and contractors, that the AIA favors the architect, hence why the consensus docs came about. But I don't know, maybe I drank the Kool-Aid, so to speak, but I think the AIA is generally pretty good documents, certainly for the architect's interest. Yeah.
Yeah, I would agree. I think they're very fair and balanced when it comes to shuffling risk. One thing to change maybe would be to get that limitation of liability in B101.
Yeah.
It's easier than to say it's industry standard. Yeah.
I know the AI has a toolkit of terms, so to speak, the B503. I don't know if you guys are aware of that document. It's kind of like it's like a cookbook, and it's like a book of terms that you can plug into the AI. They're alternative terms, and they do have a limitation liability in the B503.
They have some good explanations too.
Mhm.
You know, a lot of the cover pages, if you're just flipping through, they can kind of guide you, through the options.
Mhm. I like that document. Sometimes when I use the AI, I just actually literally, we can use that limitation liability, but it's consistent with the rest of the AI.
It is funny. We'll sometimes send, a template over to a client as a good starting point. And when we get back, the only comparison with what we sent over is the AA logo on the side. They basically just
Oh.
rewrite it sometimes, but
I can say this, the Texas Independent School District districts, if you will, are notorious for taking an AI and making so many modifications, it no longer resembles the AI they started. It's terrible. Okay, let's see here. What is the best way to have an excluded effort from a contract included within that doesn't come off as negative? So how do you sell your exclusions? Bernadette, maybe you should answer that one since you kind of were covering that general topic, if you don't mind. Talking about how to get an excluded service, I guess, without alienating your client.
Can you repeat that?
Oh, yeah. So the question is, what is the best way to have an excluded effort from a contract included within the contract that doesn't come off as negative? So I think they were asking, how do you get a list of excluded service or an excluded service in the agreement without alienating your client?
Well, I mean, there's a choice of words. You can say the same thing in so many different ways.
Mhm.
But I think contracts are, brevity is very important and clarity is very important in contracts. You don't want an ambiguous statement, because if a contract is used in litigation after the project, the ambiguous statements and lack of clarity can cause huge problems during litigation. So you want to keep it friendly, you want to keep it, avoid legalese as much as you can, keep the language simple and direct, keep clarity and brevity, and deal with the essentials. A lot of contracts that are pieced together in the last minute, they cut and paste language from all sorts of places, and they create a huge mess. They just throw it together, and but if that thing is litigated, it's all over the place. The same, a particular topic is covered in 5 different clauses. You don't know which one is the right one. It's repetition. It's very, very important to keep a structure to the contract, keep an organization, and really stick to that, and not repeat things in more than one place. Avoid repetition, and again, as much as possible, avoid legalese, language that sounds, especially for lay people who put contracts together, they assume that if they use a lot of legal terms, it just gives them more credibility. It doesn't, it just confuses things. I think for the most part, you can use simple English to get the concepts across. There are some technical terms with obviously with precise legal meaning, but those are not, that's just a small percentage of the contract. most of it is, and then of course you have to use industry terms, define your terms. Like for example, one of the main things about AIA documents is that they have given the industry over the years a vocabulary. As a result of the AIA documents, now the construction industry knows what a design development set is or what a schematic design set is. And these terms are now understood by the industry, not just by the architects or the design professionals. So terms have to be either defined or there should be industry-wide terms. Even those are sometimes defined.
You know, I think you, Merdad, you hit the nail on the head when you talk about clarity and excluded services, in my mind, at least. I think to sell it to the client, you say, if I can't put boundaries around some of these obligations, I'm going to have to reflect that in my fee. And the more precise we can be about my scope, more likely I can bring a fee that's a little lower. But if I have all these open-ended obligations, my fee is going to have to reflect that. So I think it's good for the client, so they know exactly what's going to be in their contract. And those excluded services, you know, they clarify the agreement in my view, and they're helpful to both parties.
Can I give one real life example that I feel like we deal with a lot is when the client or the owner always wants the geotech to be under us. And, you know, the way we try and explain that to the owner and we include that as try and exclude it as much as we can in our agreements, and the owner pushes and pushes. And the explanation is that we're not adding anything to that geotech. That from our standpoint, whatever is in that report, we as the architect can't look at that and do quality management or can't add anything to that. Now a contractor, they know what they're looking for. They know what they need to know from that geotech, and the owner, it's their property. A lot of times it's their land. And so they're best to mitigate. If that geotech report finds something, they're the best party to mitigate that risk of what's underneath their land. And so trying to, again, I always come back to the risk allocation is that if, a lot of the times what the owner wants to give us, if we're trying to exclude something, or we say we can't do that, it's you're only using us as a contractual vehicle. We're not adding anything. We're not providing value to you by providing this service or finding a sub underneath us to provide this service for you. It's better if someone else on the project has that.
You put a markup on that, I get that too, in your fees. Okay, very good. And then finally, we have one last more, and I'm sorry for going over, but how many times, somebody raised this, how many times have you had to pay an upfront defense? So I guess the question is, so.
A lot. I mean, it is very common, and that's part of why insurance is such a big component of the industry.
Because as they comment, the old, you used to have a guy there before you have, and he used to say, you could have a situation where the good news is, hey, you're not negligent and you have to pay for the damages. But the bad news, you agreed to pay for the upfront defense and you still got a lot of money.
Yep.
Okay, well, on behalf of everybody, Merdad, Evan, Eugene, I want to say thanks. You guys did a terrific job. I think we're all a little better educated leaving here today. So thank you.